Hi guys, this is Asal. I'm studying for the bar and today I'm studying inchoate crimes. So there are three types of inchoate crimes. There's solicitation, there's conspiracy, and there's attempt. But it'll be a really long video if I wanted to describe all three, so I'm gonna have to chop it up to 2 videos. So today I'm gonna describe attempt for you. But before I jump into what attempt is, first I would like to describe what inchoate crimes are. So basically inchoate offenses are offenses that impose liability for acts done before the harm intended fully occurs. And also now I'm going to jump in and I'm going to describe attempt for you. So attempt is conduct done with the intent to commit a crime but without actually completing it. Okay, so how do you know that the defendant intended to commit a crime? I mean, that's just such a hard thing, you know. How do you know someone intended to commit a crime? Like, can you read someone's mind? Are you telepathic? Like, it's really hard to know, right? And where do you draw the line between preparing for the crime and actually attempting it? For example, let's say I grab my doll there and like I'm mad at my ex-boyfriend and like I punched a whole bunch of needles in there, to do like the whole voodoo doll thing. Like, is that enough for it to be attempt? Or, let's just say that like I go and like I purchase a gun, like, is that attempt? Okay, so now I'm gonna describe what would be attempt. So, under the common law, there are three circumstances that are attempt. So basically, one is have the same mens rea called for by the target crime itself. Two, have a mens rea of specific intent as to the attempt. And three, intent the circumstances. Okay, so under the common law, you must have the mens rea of the specific intent as to the attempt. So basically, a defendant cannot be liable for a reckless attempt or a negligent attempt. That's just not enough. So, under the model penal code, so I just described the common law and now it's the model penal code. Attempt must have the same mens rea called for by the target crime itself, act with purpose to cause a result or a belief that the result will occur, and have the required level of culpability. Okay, so quickly I would like to describe the model penal code. I would like to compare it with the common law, and then I'm just going to jump into the next topic I'd like to talk about. So, under the model penal code, a belief that a crime or harmful result will occur is enough, sufficient for liability, but under the common law, it's insufficient for liability. Now the mens rea, okay? So under the model penal code, circumstance required for the target crime, the defendant need not intend the circumstance, whereas under the common law, the defendant must intend the circumstance. Okay, now the strict liability. Under the model penal code, circumstances required for the target crime, ignorance of necessary circumstances is not a defense, okay? Now under the common law, ignorance of necessary circumstances is a defense. So, attempt mens rea requirement, there is no liability for criminal thoughts. So as I told you before, you cannot be punished for your thoughts. There is no such thing as telepathy in law. And also, the attempt demands a culpable act, basically a step in the crime's actual commission. Now I would like to move on and I would like to describe actus reus approaches. So the first approach is the last act test. The defendant must perform the very last act needed before the crime is completed. The second approach is equivocality test. The defendant's conduct must be unequivocal. And the third one, probable desistance test. Would an ordinary law-abiding person have probably desisted from the defendant's criminal purpose? So, like, basically, would an ordinary law-abiding person be likely to change his mind at that point? And then the fourth one is the proximity test. How close was the defendant to committing the crime in the space and the time? And now the fifth one is the model penal code approach, that the defendant must take a substantial step that is strongly corroborative of the defendant's criminal purpose. Okay. So now I'd like to move on, and I would like to describe what it means to take substantial step. So you're taking substantial step when you're searching for the victim or soliciting an innocent party to perform an element of the crime, or possessing the tools necessary for the crime close to the scene or the scope of the crime scene. Okay, so now, the next thing that I would like to talk about, like right now, everything I talked about was basically the mens rea, the actus rea components. Now I would like to move on, and I would like to talk about the limitations and the defenses. This should have been a separate video, but I'm going to continue on because it's still attempt. So the next thing I want to talk about is merger. A lesser crime becomes absorbed into a greater one so that the defendant cannot be convicted of both. Okay, completed crime. A defendant cannot be convicted of both attempt and actual commission of an attempted crime. So, you cannot have double jeopardy. Abandonment is not traditionally allowed in the common law, and the actus reus of attempt is close to the completion of the crime under the common law. So, you cannot just have that abandonment. And it is also the actus reus of attempt is close to the completion of the crime, and it is extremely difficult for the defendant to abandon. And then there's also the Model Penal Code with the substantial step, and the defendant must take substantial step that is strongly corroborative of the defendant's criminal purpose. Okay, now the next thing I would like to talk about are the three elements to be satisfied for the renunciation to the function as a defense. So the first one for the renunciation to be a defense is if the target crime includes as a material element either a result or a circumstance as opposed to a mere conduct. And then the second one, the renunciation is voluntary. The third one, the renunciation is complete and final. Okay, so now that I finished talking about renunciation, the next thing I want to talk about is impossibility. So basically what happens if it's basically impossible to commit the crime? Let's say, like walking in public nude is like illegal, and like someone doesn't know that, okay? And like it's basically impossible for them they think that, okay, if they have like boxers on and they were to like flash a woman with their boxers, and that's illegal. No, you have to be completely nude in public for it to be illegal. So that's impossibility. Okay, so there are like three types of impossibility. There's legal, factual, and inherent. Factual impossibility: the defendant intends to commit a crime, but factual circumstances outside of the defendant's control prevent the crime from being committed. Inherent impossibility: the defendant intends to commit a crime and believes that the conduct will cause the intended harm. And basically, okay, so I would like to describe this for you real quick, especially now that it's like the coronavirus. So what happens if like someone like has the coronavirus and like basically spits into someone else's face, hoping that person will get the virus and die? Like, is that enough for it to be attempt? So just think about that for a second. So inherent impossibility: the defendant's conduct may be too silly to meet the mens rea and actus rea requirement to create the attempt liability. Okay, so the next thing I want to talk about is the Model Penal Code inherent impossibility. And a prosecution for attempt is dismissed if the defendant's conduct is so unlikely to result in the completion of the crime that neither the conduct nor the defendant poses a threat. Okay, that's pretty much everything I wanted to say about that. I would like to quickly wrap it up with saying that this was a specific intent crime. Remember that the definition is imperfect, partial, unfinished, begun but not yet completed, and also when the defendant acts to commit a crime but is unable to complete the target offense. There are two elements: must have the specific intent that the crime be committed, and must take substantial steps in furtherance of the crime. Okay, that's pretty much everything I wanted to talk about. So basically, yeah, when you think of inchoate crimes, think about even if the defendant does what he intended to do, but the act does not constitute a crime, then it is legally impossible to commit a crime. Think about all the defenses such as impossibility, and like that guy that I told you about with the boxer who flashed, and you know, he thought that, okay, you know, what I'm doing is illegal, when in no way, you know, that's illegal. You can go ahead and flash someone with your boxers on. Okay, so that's pretty much everything I wanted to talk about. Have fun studying. Cheers.